This was covered in CAO and council roles and responsibilities, and it is worth repeating time and time again that unless otherwise provided in the MGA, any action or proceeding of a municipal council must be authorized or adopted by a bylaw or a resolution at a duly constituted public meeting of the council. So addressing the public requirement is absolutely crucial, making sure notice of meeting is provided and that the public are invited to attend, and also making sure that council knows how they need to act, whether it's through a written resolution or through bylaw. And of course, there is the requirement that the actions of council are done or decided by a majority of the council members present at a meeting and who are entitled to vote. In terms of types of meetings of council, council holds regular meetings that must be held 6 times annually. They must be held in public, and the public must be invited to attend, which means that notice of the meeting has to be given. Notice can be given electronically, and the Act also requires that notice is given by other means. So usually a posted advertisement somewhere in the community. Closed meetings are a specific type of meeting where council can go behind closed doors and discuss matters that are of a confidential nature. And these are specific matters that are limited to those listed in section 119(1) of the MGA. So if you turn to that section, you'll see a list A through H of scenarios or matters that council is entitled to discuss behind closed doors. Now, before going into a closed meeting, there must be a resolution at a public meeting to actually close the meeting to the public, and council must disclose the type of matter that is being considered behind closed doors. Any meeting other than a regularly scheduled meeting is considered a special meeting of council, and adding items to the agenda of a special meeting requires unanimous agreement by all members of council, not just those present. So when council is considering going into a closed meeting to discuss a confidential matter without the public present, there are a few questions that need to be asked. Immediately, you'll ask, is section 119 applicable? So if you look at section 119 of the Act, you'll see immediately before the list, A through H, comes the word confidential. So the matter to be discussed must be confidential information related to any of the A through H subject matters. The reason that council members are allowed to go into a closed meeting is really to protect the public interest. So another question that needs to be asked is, will it hurt the public interest to discuss the matter in public? So just because council is in disagreement on a particular matter and may prefer to have the debate behind closed doors, that does not give council permission to actually go behind closed doors. The ultimate test is whether it will hurt the public interest to discuss the matter in public. And from a procedural perspective, have you advised the public that council will be meeting behind closed doors? And have you disclosed which section of 119 actually enables the closed meeting? So all the details that are being discussed will not be shared in that notice of meeting, but you will list what provision of section 119 is being discussed behind closed doors. And finally, once there's debate and discussion in a closed meeting, council or the committee must actually make the decision at a public meeting. So that means any agreements made behind closed doors must be ratified or finalized by resolution or by law at a public meeting.
So this is definitely a challenging area to navigate as the Chief Administrative Officer. And of course, part of your role as CAO is to inform and advise council when they are acting outside of the authority within the MGA or regulations. So if council is proposing a closed meeting when they're really not permitted to do so, as the CAO, it's part of your job to notify them of that and course correct. So this may mean that you need to provide reasons about why you need to meet in public, or explain why the Section 119 threshold has not been met to go into a closed meeting. There are also prohibitions and penalty provisions in Section 119 of the MGA that deal with circumstances where council meets behind closed doors inappropriately, or where confidential information from a closed meeting has been disclosed publicly or otherwise.
This is an excellent tool that is found on page 30 of the Municipal Handbook, and it has all the specific notice requirements and the associated provision of the MGA for your different types of meetings. So use this to make sure you've got the right type of notice during the right time frames provided, and that you comply with all the requirements under the Act, the EOR procedural bylaws, or other regulations. So the CAO's role in recording decisions made is to make sure that direction and decisions made by resolutions or bylaws are recorded accurately and are stored appropriately in the municipal records. There is a requirement for the CAO to ensure that all resolutions passed and bylaws adopted are kept in indexed registers on site at the municipal office. And of course, this is so that you as the CAO can access this information, but also so that members of the public are able to easily access information they may be seeking around council decisions and activities. In the municipal law sessions, we'll talk more about when to use bylaws and how to adopt them, and when to use resolutions. But as an overview, bylaws typically deal with matters that can have a significant effect on people and property in the municipality, where resolutions can be really used for any matter that doesn't require a bylaw. And of course, resolutions must be tabled by a mover. There must be a seconder to support the debate on the motion, and then there must be debate and a vote whether to pass or not. There are a number of different ways council can act and use their authority within the MGA. So this could be approving items or decisions or proposals. You could be adopting bylaws or proposals. You can authorize activities or actions on behalf of someone else. You may direct employees. Council can enter into a contract. You can ratify a decision, so officially approve or validate a decision that's already been debated and discussed, or rescind a motion or resolution. So that means to undo the decision that was previously made. Section 115 of the MGA addresses voting by council members. So each council member present at a meeting shall vote on every matter unless they're excused from doing so. There shall be no secret ballots or no secret votes. So again, the requirement for council to be transparent and open to the public with their decision making is absolutely crucial. The minutes of the meeting must record all votes of council, so the number of votes for and against shall be recorded. Section 115.4 talks about the mayor's right to vote, and the mayor shall vote for the purpose of breaking a tie if there is an equal number of votes for and against either a bylaw or resolution. And finally, sub 5 of section 115 talks about situations where a member of council fails or refuses to vote on a matter that is properly before the council. So if there is a failure or refusal to vote, the MGA states that that shall be considered a vote in favor of the motion, except when the member is excused by resolution of council or is prohibited from voting because the member has a conflict of interest. Here we have a sample resolution. So this may be a template that you'll use as the CAO for recording those decisions made. You want to identify the mover, so which council member brought the motion, who seconded the motion, and the text for the resolution will include some background information related to the decision. That's usually considered a whereas clause, and the be it resolved clause is the actual decision or action that is taken. And finally, the resolution and the meeting minutes will note whether the motion was carried or not. And as we just saw in section 115, the records need to show how many votes were in favor and how many votes were against. Here's an example from an actual municipality in PEI, and you'll note that the sample resolution here includes a number associated to it. So you'll want to have some sort of numbering system to keep track of all the resolutions that are passed during the year. And in this case, you simply see motion carried, and this would indicate that all votes were in favor. Otherwise, we would see how many votes in favor and how many votes are against. Section 122 of the MGA addresses how and when council can hold meetings electronically. And of course, post-COVID-19 pandemic, we're all very used to electronic meeting formats, but still the MGA requires that council and the municipality take specific steps to make sure that all the rights of the public are still respected, and that council and committee members are able to hear each other, speak to each other, and be open and transparent with all the discussions and decisions. So you'll see in the Act that electronic meetings are permitted, but they must be authorized by the procedural bylaw first, and they're only permitted if council members are unable to meet in person. That notice to the public has to state how the meeting will be held, and members of the public must be able to hear and see all the meeting participants. There have also been recent amendments to the MGA to clarify the definition of electronic meetings and to address how you have electronic meetings in states of emergency. And with respect to emergency meetings, Section 144 of the Act provides that council may make temporary measures that are necessary to respond to and deal with an emergency. So that would include holding that emergency meeting. But note that this is only appropriate in the event of an actual emergency as defined in the Emergency Measures Act. So there is a specific criteria that must be met with respect to the definition of emergency before council can go ahead and hold a meeting to deal with the situation. And of course, you may be not able to provide adequate notice to the public, and the public may not be able to attend these meetings if there is certain situations in place that prevent public attendance and adequate notification. So see the definition from the Emergency Measures Act. An emergency means a present or imminent event in respect of which the minister or municipality believes prompt coordination of action or special regulation of persons or property must be undertaken to protect the health, safety, or welfare of people or to limit damage to property.